Your Honor, myself Asutosh Samandray, plead the first murder of this criminal case, and my second murder is Miss Subhasmita Palai and Mr. Tarman Nayak is my researcher. Your Honor, may I argue on behalf of respondent?
Yes, you can proceed.
The issue in this case is whether the death of Meena within 7 years of marriage amounts to dowry death under section 304 IPC. Here the prosecution has successfully proved cruelty and harassment for dowry under section 490 IPC. Here the presumption under section 113B Evidence Act is applicable in the present case. Here the conviction passed by the trial court is valid and based on sufficient evidence. Your Honor, I shall argue on the point of two issues, and my second promoter will argue rest of two. May we submit detailed memorial points. Your Honor, for first issue, points of argument are the death clearly amounts to dowry death under section 304B IPC. Death of a woman caused by burns, bodily injury or otherwise than under normal circumstances within 7 years of marriage. Cruelty or harassment for dowry should be for death. In this present case, Meena died to the asphyxia by hanging, which is clearly an unnatural death. The death occurred within 11 months of marriage, which satisfies the statutory requirement. Her parents clearly stated that additional dowry of 1 lakh and a motorcycle was demanded. Therefore, our statutory requirements of dowry death are completely fulfilled. Your Honor, for second issue, our arguments are the prosecution has proved cruelty and harassment for dowry. The facts clearly state that 3 lakh was already given at the time of marriage. Further, dowry was demanded soon after marriage. The decade informed her mother and friend about repeated harassment. Such continuous demand for money and motorcycle amounts up to 800 section 490A IPC. The statement of parents and conduct of accused clearly established mental cruelty, which is satisfied sufficient for conviction. My second promoter will argue.
You are arguing on behalf of appellant. Appellant पे और respondent पे?
Respondent.
Oh, respondent पे लो.
तो सेट से जो appeal ये डले किसी from convict लिखी थी heading टा?
Zero टा for लो.
नहीं सर. Zero for रे. Zero for.
Respondent for रे.
अब मुझे से कौन appellant कौन से करने को?
प्रथम कौन पहले You are arguing on behalf
अरे
of
conviction for रे ना conviction against रे?
7 ବର୍ଷର ଦଣ୍ଡ ସପକ୍ଷରେ ନା ବିପକ୍ଷ?
ସପକ୍ଷରେ ମାନେ respondent?
ସପକ୍ଷରେ ମାନେ ଝିଅଟା ପାଇଁ ଲଢୁଛ. ଝିଅଟା respondent.
नहीं सर से जो heading टा
ରାସ୍ତା ଭୁଲ ହେଲା. ତାହେଲେ ଝିଅଟା ପାଇଁ ଲଢୁଛ ମାନେ
लिखिଛ appeal from convict
ଗୋଟେ ଠିକ ଲେଖିଛ. ତାହେଲେ ସେ ଝିଅ ବାଲାଟା କହୁଛି ପ୍ରୋସିକ୍ୟୁସନ ଯେ ଯୋଉ ସେଣ୍ଟେନ୍ସଟା ହେଇଛି ଯୋଗ୍ୟ ଠିକ କିନ୍ତୁ ଗୋଟେ ଜାଗାରେ ଲେଖିଛି ଯୋଉ ଡିଆଡିଟ୍ କରିଛି ଏଇଟା ଠିକ ଅଛି ଅପୋଲ୍ଡ ଦିସ୍ ସେଣ୍ଟେନ୍ସ ଆଉ ଗୋଟିଏ ଭୁଲ ଅଛି ଡିସମିସ୍ ଦି ଅପିଲ୍
नहीं सर फेस फ्रंट पेज टा देखो
वो तो से जानना
रेस्पोंडेंट से बड़े पहुंचे
हां वो
My second promoter will argue.
May I proceed, Honor? Your Honor, my argument for third issue are presumption under section 113 B of the Evidence Act applies. As per section 113B Evidence Act says, when a woman dies within 7 years of marriage and it is proved that she was subjected to cruelty for dowry, the court shall presume that the husband caused the dowry death. Since both conditions are satisfied in the present case, the burden shifts to the accused. And and the appellant has failed to produce any evidence to refute this presumption. Your Honor, our fourth point of argument are the trial court rightly relied on postmortem report confirming unnatural death and evidence of parents regarding dowry demands and evidence of harassment soon before death, and the sentence of 7 years rigorous imprisonment is the minimum punishment prescribed under section 304B IPC. Therefore, the appellant cannot claim false infliction without any supporting proof.
अच्छा गोटे कई कहना जोटा तुम कह इन ऑल क्रिमिनल केसेस द बर्डन ऑफ प्रूफ अंडर सेक्शन 101 and 102 of evidence lies on prosecution to go beyond all reasonable doubt and make the courts believe that the defense is guilty, he should be punished. এবং বর্ডনটা কইলে তুমি শিফট করিব বর্ডন যে শিফট করে অন্য শাখারে শিফট করে না আর কেউ শাখারে শিফট করে এভিডেন্সিয়াল বর্ডন না লিগাল বর্ডন কইলে ঠিক তো কইলে নি এভিডেন্সিয়াল বর্ডন কেতটা জিনিস প্রুভ করে পড়ি কেতটা প্রুভ করে অন্য শাখারে শিফট বর্ডন কেবে শিফটিং নেচার নু
তারপরে 105 রে যেটা আউটর বর্ডনটা লাইন করে পাস করে হ্যাঁ
আচ্ছা তো পড়ি নি হ্যাঁ
Presumption of dowry death must apply. Minor contradictions in witness statement do not destroy prosecution case in dowry death matters. Your Honor, may we pray on behalf of respondent Meena Das and uphold the sentence of 7 years rigorous imprisonment passed by the trial court, passed any other order which this honorable court may deem fit in the interest of justice.
Can you agree 498A is one of the negative weapon of a girl to accuse any male person?
There are many number of cases of domestic violence is 498 रे झियो माने कोन
Nowadays,
पुरुष मानकु विक्टिम करंतनी फिजिकल हरासमेंट
But 498 जदि भी
498A.
498 IPC अनुसार
पुरुष डोमिनेटेड सोसाइटी जनरली लोक कहबे
But critically it is women centric.
किंतु there are many women who have a tendency to harass also purush. It's a male dominated society.
The law is for shield, not for sword.
Shield
Don't you think
भक्षक shield माने घोड़ी रखी sword माने
we are new so
Okay, ठीक ଅଛି ଆମେ क्वेश्चन पचारे କଥା ଆମେ क्वेश्चन पचारे
ପିଲା ପିଲା ଯଥେଷ୍ଟ ଭଲ କିଛି ଖରାପ
ବହୁତ ଭଲ କରୁଛ
ଦେଖ 10-15ଟା କରିଗଲେ କ'ଣ ବି କ'ଣ କରିବେ ପାଟିର ଫ୍ଲୁଏନ୍ସି ବଢ଼ିବ ଜାଣିବ ଟିକେ ଟିକେ ମାଇନର ମିଷ୍ଟେକ୍ କରିଦେଉଛ ହଉ ଯା